I'm going to speak about the Insurance Act of 2015 and the right of an insurer to avoid a claim for breach of duty of fair representation. This is circumstances where you or your client makes a claim on a policy and the insurer comes along and says, well, actually, we're not going to pay because you didn't tell us something about it. And if you'd told us that, we wouldn't have insured it. The history of this is that insurance contracts were always regarded as being contracts of utmost good faith. This actually gave insurers a huge advantage when dealing with claims because it meant that they could basically decline a claim for the most minor misrepresentation or non-disclosure. The history of it was that the principle of utmost good faith arose in marine insurance, but the actual case that set it out in law wasn't a marine insurance case. The case was slightly different. It was the case of Carter and Bohm in 1776. And it has some sort of interesting facts which I'll tell you about. Mr. George Carter, was the governor of Fort Marlborough on the island of Sumatra in the East Indies, what is now Indonesia, in 1759. Now, Fort Marlborough wasn't actually a military establishment. It was really just a secure mercantile building. And it was secured against attack from the local Sumatrans, but it wasn't actually equipped to withstand from a attack from a foreign enemy. Now, at that time, the English and the French, the relations between us across the Channel were not as they are today, we hope. And so Mr. Carter wanted to insure his fort, or his mercantile building, against capture by the French army. And so he went to Mr. Bohm, who was an underwriter, basically for Lloyd's underwriter. And he took out insurance on his fort against capture by a foreign enemy. But he didn't tell Mr. Bohm that the fort wasn't really a military establishment. It hadn't been designed to withstand attack from a foreign enemy. And he didn't tell them that he knew that the French actually had designs on this fort and they were going to try and get their hands on it. But nevertheless, he got insurance for a year, all well and good. But what he hadn't allowed for is a certain Charles-Henri Hector d'Estaing. Monsieur d'Estaing was a general in the French army. He'd been captured and taken prisoner by the English in the 7 Years' War in India and imprisoned in Madras. But he'd negotiated his parole. Now, a parole is where a prisoner of war promises to his captor that he won't actually, if they release him, he won't take up arms against them. So he basically promised, if you let me go, I'll go back to France and you won't hear from me again. And so they did, they released him. But what he did actually was to leave the army and join the French Navy, and was immediately promoted to the rank of admiral. And he sailed around the seas capturing other boats. That was the way that you built up a fleet, was we basically went and captured other ships. And having done so, he led an attack on Fort Marlborough and seized it and took it by force. We'll come back to Monsieur d'Estaing later. Anyway, Mr. Carter made a claim. Mr. Bohm refused to pay it because he said, well, first of all, you didn't tell me that the fort that I was insuring wasn't designed to withstand foreign attack. And also, you didn't tell me that the French had designs on it anyway. And if I'd known that, I wouldn't have insured it. And it went to court. And the court, on the facts, decided that, in fact, it was common knowledge that the French had designs on this fort. So he didn't really need to disclose something that was actually common knowledge. And also, he hadn't actually misrepresented the fort. Although the title was Fort Marlborough, there was enough information that he'd given to put Mr. Bohm on inquiry that he should have asked a few more questions and would have ascertained actually that it wasn't really a military establishment. So on the facts, there was no non-disclosure. But in his judgment, Lord Mansfield set out this basic principle that a policy of insurance is one of utmost good faith, and that a breach by either party entitles the other party to avoid the policy. Now, that might have been good law in 1776. I'm not so sure it was good law, but nevertheless, it became enshrined in contract law, gave insurers huge powers to refuse claims, and then was codified in the Marine Insurance Act of 1905. Although it's the Marine Insurance Act, it actually applied to all insurance policies. And it set out this principle, section 17, contract of marine insurance is based on the utmost good faith. And if the utmost good faith is not observed by either party, the contract may be avoided by the other party. Now, I think that's bad law, because it means that an insurer can refuse to deal with a claim, or could refuse to deal with a claim under the Act, even in circumstances where it might be that they still would have insured the risk, but charged a higher premium. They can turn around and say, well, we're not dealing with a claim at all. Or they may have imposed a different term on the policy, perhaps an excess or a deductible of some sort. So they would still have had to deal with a claim, but charged an excess. No breach of good faith meant they were entitled to decline the claim entirely. And this remained the law until the Insurance Act of 2015, and before that, the Consumer Insurance Disclosure and Representations Act of 2012. The provisions under these two acts are broadly the same in relation to non-disclosure and misrepresentation. And they change the situation now. They rebalance it. They seek to rebalance it. If a policyholder makes a deliberate or reckless non-disclosure or misrepresentation, then the insurer may avoid the contract and avoid all claims. But crucially, where there's a non-deliberate, a non-reckless non-disclosure or misrepresentation, if the insurer, had there been no misrepresentation or non-disclosure, they would still have entered the contract, but perhaps on slightly different terms, imposed an excess or something, then the insurer is required to deal with the claim as if those terms had been incorporated. So they can't just avoid the claim at all, they just have to deal with what would have happened had the disclosure been made. If they would have charged a higher premium, then they just pay the amount of the claim in the same proportion as the premium actually paid applies to the premium they would have charged. So that seeks to rebalance it out. It says, well, what would have happened? What would the insurer have done had there been no misrepresentation or non-disclosure? But insurers being insurers, in my slightly cynical view, is they still want their cake and eat it, shall we say. Because what they now tend to say is that, well, we wouldn't have insured at all. No matter what if you told us the correct information, we simply wouldn't have insured. That would be their default position. But that, I think, places too much of an emphasis on the contract, because it's very rare that an insurer will refuse to take on any risk at all. They will usually have some policy that deals with a proposal. They're in business to sell insurance. So no matter what the risk, they will usually take it on, but not necessarily on the policy that they actually gave out on this occasion. For example, you might have a shops and offices policy, which it turns out is insuring a workshop. Well, the insurer will say, well, if we'd known it was a workshop, we wouldn't have given insurance on our shops and offices policy. Well, maybe not, but they would have insured it under their workshop policy. And so I say, actually, that's not an occasion where they can say, well, we wouldn't have contracted at all. They would have actually contracted, but on a different policy. Unfortunately, this hasn't really been explored in the higher courts too much. The only real case where this has come up was a case of Bait and Aviva, where a gentleman insured his Rolex watch for £190,000 against accidental loss. And funnily enough, he accidentally lost it. And what he hadn't told the insurer was that he'd had another watch of similar value, which he'd accidentally lost and made a claim for. And on that occasion, the second underwriter came and gave evidence and said, well, if I'd been told that he'd actually already lost one watch for £190,000, I wouldn't have insured another occasion. And on that occasion, the judge did actually accept the underwriter's evidence, so the claim was declined. The single point I want to raise out of this is where you have a disputed insurance claim, the insurer's default position will always be, we wouldn't have insured, and therefore we're not dealing with a claim. I say that's not necessarily the position. You've got to look at their portfolio of policies and find out, was there another policy that they offered that would actually have responded or dealt with this claim? And it might require a little bit of mystery shopping on you or your client's behalf. What I will do now is go back and tell you about Charles d'Estaing, because he did eventually get his comeuppance, you'd be really interested to know. On his return voyage from Indonesia, Sumatra, back to France, he was actually captured by the English in the Channel. And he was arrested and taken to Portsmouth, and he was charged with violating his parole. The Portsmouth bar took the cab rank rule fairly literally and represented him and obtained bail. And he was released on bail subject to a residence permit to an address in London. So he went off to London, and in due course he stood trial and was acquitted of all charges and released back to France. So I don't know what Keir Starmer's predecessor of Director of Public Prosecutions was up to, but they obviously didn't bring a very effective case against him. When he got back to France, he was welcomed as something of a hero and was immediately promoted to the rank of Field Marshal. And he was made governor of the Leeward Islands, which sounds like a rather cushy number. But then he rejoined the French army and he fought for France in the American War of Independence. Needless to say, the French fought on the side of the Americans on that occasion. But that really was the height of his achievements, because then he made the unfortunate error of getting involved in French politics and got caught up in the French Revolution and sided with the royal family, which was a mistake. In due course, he was convicted of being a reactionary and was sent to the guillotine. However, shortly before his execution in 1794, he left a note. And the note said, "After my head rolls off, send it to the English. They'll pay good money for it." Well, actually, I think his contribution to English law was rather more long-term than that, because he was, in his activities, what he did actually was to contribute to the creation of what I say was very bad law, which has only been partly remedied in the Insurance Act of 2015. So perhaps he did more damage to the English than he initially anticipated.